Good evening. I'm really glad to welcome you all to this year's Frank Guarini Government Lecture. Congressman Guarini is a distinguished graduate of this law school, a 7-term congressman, a member of the New Jersey State Senate before that, and a very devoted supporter of this school in many respects, including through this lecture series. And so we are tremendously grateful to Frank, though he couldn't be with us here tonight, for his support of this lecture and for so much else here at the law school. And we're thrilled that NYU Law alumnus Kent Hirozawa is this year's Guarini lecturer. Kent has had a distinguished career in government service, having served on the National Labor Relations Board after being appointed to that post by President Obama. He previously was chief counsel to the Nlrb chair, and before that, had a very long and distinguished career in private practice representing workers, unions, and employee benefits funds for more than 20 years. As I say, he's a graduate of this law school and was most recently here as a visiting scholar, and we're thrilled to have him here this evening to present this year's Guarini lecture. So without further ado, Kent Hirozawa.
Thank you, Trevor, for the kind introduction and for your generosity in hosting me here this spring. When my term as a board member expired towards the end of August last year, I had been nominated by President Obama for another term. Naturally, the Senate hadn't acted on the nomination, which had been pending since April, and it was clear that nothing would happen before the election. So the idea was that I should lay low and stay out of trouble and wait and see what happened. Well, by sometime on election night, it was clear that I should start thinking about something else to do. And I had loved being a labor lawyer before going to Washington, but I wasn't quite ready to jump back into the fray. I felt like I needed a transition, and Dean Morrison came to the rescue. He was kind enough to offer me a place here as a visiting scholar. Now, for those of you who aren't familiar with the law school or haven't been here in a while, there's a dizzying wealth of intellectual activity going on here. And this is in addition to the world-class teaching and clinics and programs for students outside the classroom. So the opportunity to partake of the intellectual life of the law school was a tremendous gift, as was the luxury of time and library privileges to read articles and books that I hadn't been able to get to when I was on the board. And just to step back and look at the big picture. One NLRB related topic I thought would be interesting to look at is the trajectory of the board's cases in the Supreme Court. Now, anyone who studies or practices labor law has a rough idea of it, but there's much more there, some of which has not yet been done. Of course, that would be a substantial undertaking, but a much smaller inquiry is to just look at the numbers, and so that's what I did. This didn't seem to have been done already. At least I couldn't find anything, so I took a look at it one afternoon, and the numbers alone tell an interesting, if unsurprising, story. So this shows the number of substantive decisions issued by the court in cases in which the board was a party for 5-year periods starting in 1935, when the National Labor Relations Act became law, and continuing through 2009, the year before I went to the board as chief counsel. So a couple of footnotes. The number for the first 5-year period is lower because of the startup lag time and the time it took for the first cases to get to the board. So there weren't any cases in 1935 and 1936. The first of the court's decisions in Nlrb v. Jones and Laughlin Steele, affirming the constitutionality of the act, didn't issue until 1937, and the pace after that was basically the same as in the 1940 period. And then the other one, I don't want to get too geeky here, is that for the last period on the chart, it's not that the printer ran out of blue ink. It's that the number is 0. In fact, the last decision in the preceding period came down in June 2002. That was B and K construction for the law professors and labor lawyers in the room. So you're looking at over 7 years of 0. So what's going on here? Part of it is that the act is over 80 years old, and the last substantive amendments were in 1959. At this point, the court has probably resolved most of the major questions concerning the act, for better or worse. And then there's also the fact that the court is issuing fewer decisions than it did in the 30s and 40s. Longer opinions, smaller caseload. So there's that, but perhaps the biggest factor is the dramatic decline in union density in the last 60 years. Union density is the proportion of members of the workforce who are represented by a union. So this chart gives you a little historical context, taking it back to the late 19th century. You see the explosive growth in union membership in the first 10 years after the act went into effect from 1935 to 1945, then a continuous decline starting in the late 50s and accelerating in the late 70s and 80s. A substantial part of the board's caseload involves union organizing and collective bargaining. So if you have fewer union members, you're going to have fewer cases at the board and fewer making their way to the court. Of course, the decline in the rate of union membership has affected a lot more than the Supreme Court's Nlrb caseload. Perhaps the most significant development has been the growth in income inequality. For a quarter century leading up to 1973, the compensation of rank and file workers rose in lockstep with the economy's gains in productivity. In other words, workers got a proportionate share of the productivity increase. But starting around 1973, productivity continued to rise, but hourly compensation flattened out. Workers were no longer sharing in the productivity gains of the economy. This change coincided with the drop in union density below 25%. Here's another look at the correlation. The middle class share of aggregate income, that's the blue line, in this chart refers to the middle 3 quintiles of income earners. In other words, leaving out the top 20% and the bottom 20%. So this is pretty striking, right? We all know that correlation does not prove causation, and it's clear that a number of different factors have contributed to the growth of income inequality. But there are now some studies that persuasively establish a causal link. I would single out sociologist Jake Rosenfeld's recent book titled What Unions No Longer Do. Here's a different angle on the correlation. Those productivity gains that rank and file workers no longer share in are going somewhere. And here's a more focused view of some of the winners. Okay, the board and the court. So, since 2009, the last year covered by the chart, the court has issued decisions in 3 NLRB cases. Now, that doesn't mean we can say, we're back. But especially since none of these decisions even addresses a substantive labor law issue, but they do shine a light on the agency's current place in American political life and the changing reality of governing. There were 3 cases: New Process Steel v. NLRB, NLRB v. Noel Canning, and NLRB v. Southwest General. And I started out wanting to talk about all 3 and then realized that was just too much, especially Noel Canning, which addresses the president's recess appointment powers. So what I'm going to do, just not to drive everyone out of the room, is stick to the first one, New Process Steel, which I think is probably the least known because it's the narrowest in its application. It involves the Quorum provision of the National Labor Relations Act. The story begins in September 2007. That month, the board, with a Republican majority appointed by President George W. Bush, issued over 60 decisions, many of them controversial. And that became known, at least to some, as the September Massacre. Senate Democrats, who had recently regained control of the chamber after the 2006 midterm elections, took a dim view of this development, and they resolved not to permit President Bush to fill any of the vacancies that would arise when the term of Chairman Batista expired in mid-December, and the 2 recess appointments lapsed at the end of that month of December. As constituted since the 1947 amendments to the Act, the board has 5 members. The members are appointed by the President with the advice and consent of the Senate. 3 members are required for a quorum, and the board may and routinely does delegate its authority to groups of at least 3 members. In practice, 3 members. In late December, after Chairman Batista's term had expired, but with the 2 recess appointees still in office, so with a total of 4 members, the board delegated its authority to a 3-member group that included one of the recess appointees. They had to have at least one of them, with the express understanding that following the end of the recess appointments, the remaining 2 members could exercise the board's authority as a quorum of the 3-member group. Got that? This legal analysis the legal analysis supporting this approach came from a 2003 opinion of the Office of Legal Counsel. And, you know, they're pretty smart over there, so they figured this ought to work. With the end of the month, the board went down to 2 members. Wilma Liebman, a Democrat who was originally appointed by President Clinton, and Peter Schomburg, a Republican who was appointed by President Bush in his first term. So in January 2008, the board began issuing decisions pursuant to the December delegation. In September 2008, the 2-member board issued 2 decisions upholding findings of unfair labor practices by New Process Steel. The company petitioned the 7th Circuit for review of the orders, arguing, among other things, that the 2-member board lacked authority to issue the orders. Meanwhile, Barack Obama won the 2008 election, and in the spring of 2009 nominated 2 Democrats and 1 Republican to fill the vacancies on the board, following the long-standing tradition of including on the board members from the party out of power. One of the nominees, Craig Becker, was, in my opinion, the most qualified individual ever nominated to serve on the board. After practicing with a labor law firm in Washington for a few years, he had been a law professor, produced some significant labor law scholarship, and then returned to practice as Associate General Counsel of the AFL-CIO and of the Service Employees International Union. He combined a deep knowledge of the law, its history, and the policy considerations underlying it with years of experience in bargaining, arbitration, and practice before the board. In addition, he's a team player and very deliberate and cautious in his approach to any issue. In short, the complete package. In October 2009, the Senate Committee on Health, Education, Labor, and Pensions, affectionately known as the HELP Committee, voted to send all 3 nominations to the full Senate. 2 of the nominees were approved unanimously, and Becker by a bipartisan vote, including 2 Republican senators, one of them the ranking member of the committee. Immediately following the committee vote, however, Senator John McCain put a hold on Becker's nomination. That meant that cloture would have to be invoked, cloture, the cutting off of debate, would have to be invoked to get the nomination to the full Senate. The cloture process involves presenting a cloture petition, waiting for a specified period of time, then holding a vote. At the time, 60 votes were required to invoke cloture on nominations. In late January 2010, Senate Majority Leader Harry Reid filed cloture petitions for the nominations of Becker and Patricia Smith, then the New York Commissioner of Labor and the nominee for Solicitor of Labor. So those were filed together, and he scheduled the votes on both of them for the following Monday, February 1st. Senator McCain immediately demanded a hearing on Becker's nomination, the first for a board member nomination other than chairman, for about 30 years. So that Thursday afternoon, January 28th, the hearing was scheduled for the following Tuesday, February 2nd, with the committee vote to be held the following week. And as a result of that, the cloture petition had to be withdrawn. What followed was a weekend of preparation and then an uneventful hearing on the Tuesday. In the meantime, the vote for cloture on Patricia Smith's nomination went forward on February 1st, on the Monday, the day before the hearing, and passed with 60 votes. In other words, not a single vote to spare. Now, the preceding August, Senator Ted Kennedy had passed away. His seat was to be filled through a special election, and Paul Kirk, a former Kennedy aide and former DNC chairman, was appointed to serve in the interim. He was not a candidate in the special election. He was just filling the seat during the election process. One of the 60 votes for cloture, for the cloture petition on Patricia Smith, was cast by Paul Kirk. In the meantime, a few weeks before, more like a week and a half before, Scott Brown had won the special election, but was taking his time moving down to Washington. And so the February 1st cloture vote was a wake-up call for the Republicans. We don't know exactly what happened, but Brown immediately flew down to Washington and demanded to be seated. So he was sworn in on February 4th, 2 days after the Becker hearing. The next week, the committee voted a second time on the Becker nomination, and this time it was a straight party line vote. The two Republican votes in favor from October had disappeared. While all of this was going on, the two-member board continued to decide cases and issue decisions pursuant to the delegation. That period finally ended after the president's recess appointments of Becker and the other Democratic nominee, Mark Pearce, on March 27th. So over the 27 months of its existence, the two-member board issued over 600 decisions. In New Process Steel, the Seventh Circuit rejected the company's quorum arguments and enforced the board's order. On the same day, however, the DC Circuit issued a decision in a different case reaching the opposite conclusion. A number of other circuits weighed in, most of them upholding the board's authority. The Supreme Court granted cert to resolve the conflict, and the case was argued just 4 days before the recess appointments. On June 17th, the court handed down its decision, holding that the board's delegated authority could no longer be exercised once the board's membership fell to 2. The New Process Steel decision raised the stakes and set the stage for the next case. Later that summer, member Pearce and the Republican nominee, who had not been recess appointed, Brian Hayes, were confirmed as part of a large group of nominees acted on together by the Senate. The terms of members Schomburg and Liebman, I apologize for not providing a scorecard for this. They expired in August of 2010 and 2011, respectively, so that dropped the number of members to 3. So when member Becker's service ended a few minutes after noon on January 3rd, 2012, the board was again without a quorum. And this time that was clear under New Process Steel. The president had previously nominated a Republican and 2 Democrats for the 2 pre-existing vacancies and for Member Becker's seat. On January 4th, the day after the end of Member Becker's service, recess appointments of all 3 nominees were announced. One of the first decisions issued by the newly reconstituted board involved Noel Canning, a Pepsi distributor in the state of Washington. With the support of the U.S. Chamber of Commerce, the company petitioned for review in the D.C. Circuit, arguing that the appointments exceeded the president's power under the Recess Appointments Clause of the Constitution. The implications of this case were far greater than New Process Steel. Hundreds of federal officials had received recess appointments from presidents of both parties. And you had boldface names like Alan Greenspan down to unpaid members of advisory boards. So this had been routine and at a certain time uncontroversial, but as conflict between presidents and the Senate over policy and personnel grew, and confirmations of nominees became more commonly and bitterly contested, recess appointments became more controversial. Toward the end of the last Bush administration, Senate Democrats followed a practice of holding pro forma sessions every several days. During a Senate recess, a designated senator would gavel the Senate into session, then gavel it out with no business having been transacted. The purpose was to prevent a recess from lasting long enough to permit recess appointments under the prevailing norms. So this was the practice that by making the recess appointments to the board and preventing the board from losing a quorum, President Obama challenged. And as I promised, I'm not going to get into all the ins and outs of that case, but the end result was that the Supreme Court essentially set aside over 100 years of practice and precedent in holding that the recess appointments were invalid. The third case, Nlrb v. Southwest General, involved the appointment of an acting general counsel under the Federal Vacancies Act. This was this involved a whole different area of controversy. The acting general counsel, Leif Solomon, was a career board employee, should have been non-controversial, but he had committed a cardinal sin. There was a complaint, or a charge, I should say, that was filed in Region 19 in Seattle against the Boeing company. The charge alleged that the company had made certain threats to move work out of Washington and to South Carolina to a new plant that it was constructing there because of union activity in the state of Washington. And the allegations of the charge and the evidence that the charging party presented clearly made out a prima facie case, but there was an outcry that the board was trying to tell companies where they could invest and where they could build, and one afternoon, Leif received a call from a senator who told him that if he approved issuing the complaint in the Boeing case, he would never be confirmed. So that was a profiles in courage moment. He approved the complaint because that was the right thing to do, and he was never confirmed. And he knew that he would never be confirmed, but he continued as acting general counsel. But at that point, he was a lightning rod for, among other things, litigation. So there were a series of challenges to his appointment as acting under the Vacancies Act, and a whole series of different arguments were made. And finally, in Southwest General, there was an argument, which is a very technical argument based on the language of the Vacancies Act that I won't trouble you with, but the Supreme Court ultimately ruled that he hadn't been properly appointed. So this is really, and these three cases are part of an extraordinary series of events affecting a federal agency. And what they highlight is that the board and the act are situated in the midst of very strong cross-currents in American politics and society. There's some sectors of political opinion that have never accepted the legitimacy of the New Deal. There's some that may have seen the act as a necessary evil to channel and regulate worker militancy at the time when it was enacted, but is no longer needed. There are some who simply see unions as outmoded impediments to the efficient functioning of a business. On the other hand, there are those who see unions as essential to a fair distribution of the rewards of the economy. And there are those on both ends of the spectrum who see unions as the largest group of non-governmental organizations that tend to support progressive candidates and policies that see them as a force either to be contended with or to work with. All of them see the board and the act as supportive of unions. This isn't surprising given that the act protects employee union activity and has the express purpose, among others, of encouraging collective bargaining. Among the results of this situation are the determined and passionate attacks on the agency and equally passionate support. Where it will all come out, I don't pretend to know. I was wrong on so many of my predictions when I was in Washington, but I think it's safe to say that it's far from over. Thanks for listening. Any questions? Amelia?
I think you mentioned how many cases were invalidated as a result of the process deal, but in terms of the aggregate total of the cases that were largely sort of the findings of which were eviscerated, as between new process deal and no canon, do you have a total number of basically how much work had to either be redone or re-examined by the board?
You know, the numbers weren't that different, but but Noel Canning ended up being more work to redo all those cases, because basically the effect of those rulings was that each of the decisions issued by the improperly constituted board was a nullity, and so the case was still waiting for a decision. So we had to redo all of them. The ones in new process steel were relatively easy, because those were all decided by two members with very different views of the act and of the issues. And so for the two of them to agree on a result and a rationale, the right answer had to be pretty obvious. So those were disposed of pretty quickly. Noel Canning took, those cases took a lot longer. I mean, some of them were very routine, but there were also some hard cases there, and hard issues, and some of which weren't addressed until the very end of my term, like 3 years later. One example is the Alan Ritchie case, which was that the actual Alan Ritchie case was settled in the interim, but the issue ended up being addressed in total security. So Phil.
Right, so you showed us the statistics about declining union density over the last several decades. And I'd be curious as to your views as to what extent is that due to macroeconomic forces and changes in the labor market? That would be explanation number one. Explanation number two would be the woefully weak punishments in the federal labor laws for unfair labor practices and other aspects of the federal labor law that pro-union policymakers have complained about over the years.
I think it's clear that there's no single cause, and that those are both factors, and I don't know that it's ever been quantified, like the relative responsibility for this trend of different causes has ever been quantified. I think there are at least a couple people in the room who are better informed than I am on this particular subject. If either or any of you would like to take a stab at it.
Well, union density has fallen in the whole industrialized world. It's fallen much faster in the so-called Anglo-American systems, which are more enterprise-based for obvious reasons. competition between enterprises has contributed. But I think it's fallen worst of all in the US. And then I think the contribution of unfair labor practices that are inadequately deterred and inadequately remedied surely play a role.
Okay, thank you.
I'll just take up a few reasons. The decline of manufacturing percentage of the workforce. Much workplaces that have 5,000 workers in one place, and in ways easier to unionize them. And now workplaces are generally smaller, and employers are fighting far harder against unionization than was the case 20, 30, 40, 50 years ago. That's separate from the lack of penalty, but it's related to the lack of penalty. David Weil, former head of the Wage and Hour Division, wrote a terrific book on the fishing of the workforce, so that the contract caps then near far harder to unionize. The rules for unionizing them are very complex, and that falls on the rights of Uber and right service economy jobs are banking and nail salons. They're hard to do. So there are many reasons. It's not just that the companies are inadequate. But I think Cindy's right that employers in the United States fight harder against unions than in any other industrialized nation.
I apologize for not asking our friends to introduce themselves. Cindy Eslin, professor of law here at NYU, and I think the scholar who's done the most interesting and thoughtful work in the area of labor law in the last several decades. Steve Greenhouse, longtime labor reporter for the New York Times, and still very busy reporting while he finishes his second book. The first one, The Big Squeeze, was a terrific account of the challenges that American workers face, and definitely worth reading, and we're all looking forward to the next one. Miles.
So I had a couple questions that are kind of related. You have this graph here, the volume of cases, Nlrb cases in the Supreme Court. What are the characteristics of an Nlrb case that makes it to the Supreme Court? Is it that it's a question that hasn't been resolved yet? Precedent for it? Is it that what drives that, and how is that related to the union density question? And does it mean that there are no longer big questions that are being brought in front of the NLRB?
There are the question of what gets a case to the Supreme Court. There are lots of articles and even books written about that, but there has to be a question that needs to be resolved, usually a split among different courts of appeals, the next layer, the layer below the Supreme Court in the federal system of the judicial system, and a significant enough question to warrant the court's time, because they only issue, at this point, I think, barely 100 decisions a year. Nancy?
Seems like these recent cases are really all about whether the Nlrb gets to function at all by any mode. And I wonder, you mentioned the first cases about sort of the legality of the act, but over those years, were there other cases that were of this type, or is this just a new thing within a polarized political situation? The cases are all about whether the Nlrb gets to even do its work.
Well, I mean, that's definitely what was going on. How new it is, when the act first went into effect, there was massive resistance in American industry. There was widespread belief in at least some parts of the business community that the act was unconstitutional and that it would be gone within a matter of years or months, and it took a few years of enforcement to get past that, and there are ways in which we've never really gotten past it. The plan, just as there was a plan, an articulated plan to prevent President Obama from achieving anything at all, there was I think a plan among at least some people to keep the board from functioning, and that was reflected in what you see in these cases, and more directly, ever since the Republicans took control of the House after the 2010 midterm elections, there has been introduced, I think in most or all of the sessions, a bill to set the agency's budget at zero. There have been riders budget riders to prohibit the agency from spending money to enforce the National Labor Relations Act. So yes, it has been that kind of thing. I think there's just been, because of the changes in politics, which we see reflected in many different ways, there have been more opportunities to do that. Steve.
Hypothetically, if a union brought the Mill County case and tried to strike overcome a two-person quorum, or if the union had brought the due process guilt case saying the appointment of the appointments were improper, or a union had said that the council was improperly appointed, do you think the board would, do you think the Supreme Court would rule the same way?
What do you think? I mean,
They're very principled, of course they would have ruled the same.
Anything else? Is it time for refreshments and reception? All right, well, thank you all for coming.